Imagine you are an insider. You have confidential information about your company. The market does not know it yet. You do not trade. Instead, you simply send the information to someone you trust. You tell your friend, your advisor, your relative, or even another insider. Can that simple message become an insider trading violation? And here is the bigger question. What if you have a completely legitimate reason to share the information? What if the information is required for a merger? What if a lawyer needs it? What if a merchant banker needs it? What if the board believes the transaction is in the best interest of the company? And what happens if an insider trades while possessing that information? Today we are going to answer all of these questions. Because Regulation 3 controls communication and procurement of unpublished price-sensitive information, and Regulation 4 controls trading while in possession of unpublished price-sensitive information. This is SEBI Insider Masterclass Series Lecture 2. And throughout today's lecture, remember one question. Who has the information? Why was it shared? And what happened after that? Welcome back to Corporate and Securities Law Compass. Navigating the law with clarity. Today we will study Regulation 3 in detail. Communication or procurement of unpublished price-sensitive information. We will understand Regulation 3 Sub-Regulation 1. When an insider cannot communicate UPSI, then Regulation 3 Sub-Regulation 2. When a person cannot procure UPSI, then the important exceptions under Regulation 3 Sub-Regulation 3. Legitimate purposes, performance of duties, discharge of legal obligations, transactions involving open offers, transactions considered to be in the best interests of the company. Then we will understand Regulation 3 Sub-Regulation 4, confidentiality and non-disclosure requirements. Then Regulation 3 Sub-Regulation 5, structured digital database. Then Regulation 3 Sub-Regulation 6, preservation of the structured digital database. After that, move to Regulation 4. Trading when in possession of unpublished price-sensitive information. We will understand the basic prohibition. The presumption that trading was motivated by knowledge and awareness of UPSI, and the circumstances through which an insider may demonstrate innocence. Finally, I will give you practical secretarial audit questions, so stay until the end. Remember ABC Limited from Lecture 1? ABC Limited is a listed company. The company is preparing its financial results. The results are significantly better than expected. But the results have not yet been made generally available. The CFO knows. The managing director knows. The company secretary knows. Certain directors know. The statutory auditor knows. The legal advisor knows. And several employees have access to the information. This information may be UPSI. Now the CFO sends the information to his friend. The friend does not work for ABC Limited. The CFO says, I did not trade. I only shared the information. Is that enough to avoid liability? This is where Regulation 3 begins. Regulation 3, communication or permission of UPSI. Regulation 3 Sub-Regulation 1 starts with a very strong rule. No insider shall communicate, provide, or allow access to any unpublished price-sensitive information relating to securities listed or proposed to be listed. And this prohibition applies to any person, including another insider. But there is an important exception. The communication can be made where it is in furtherance of legitimate purposes, performance of duties, or discharge of legal obligations. So remember the basic formula. Communication of UPSI is prohibited unless the communication falls within the permitted circumstances. The big question: why does the regulation prohibit communication? Because UPSI is valuable information. If one person receives information before the market, that person may have an unfair informational advantage. The regulation, therefore, expects UPSI to be handled carefully, on a need to know basis. This is the philosophy behind Regulation 3. Practical example: ABC Limited is negotiating a major acquisition. Only a small group knows about the transaction. The company secretary sends the transaction details to the legal advisor. Is that automatically prohibited? No. Now ask, why was the information shared? If the legal advisor needs the information to perform professional duties, the communication may fall within a legitimate purpose. But that does not mean the information can be casually circulated. The company must control the information. Regulation 3, Sub-Regulation 2. Now let's reverse the situation. The insider is not voluntarily communicating the information. Another person is trying to obtain it. Regulation 3, Sub-Regulation 2 says that no person shall procure from or cause the communication by any insider of UPSI except in furtherance of legitimate purposes, performance of duties, or discharge of legal obligations. So the prohibition works in both directions. The insider cannot unlawfully communicate, and another person cannot unlawfully procure. Practical example: imagine an employee knows about an upcoming acquisition. A friend calls the employee. The friend says, "Tell me the name of the company ABC Limited is acquiring." The friend is trying to obtain UPSI. The employee should not disclose it merely because the friend asks. This is where Regulation 3, Sub-Regulation 2 becomes important. Now imagine the same acquisition, but this time the company appoints a merchant banker. The merchant banker needs the information to perform its professional role. The information is being shared for a genuine corporate transaction. Now the question changes. This may be a legitimate purpose, but the compliance controls do not disappear. Confidentiality still matters. Regulation 3, Sub-Regulation 3. Now we reach a very important exception. The regulation permits communication, provision, access, or procurement of UPSI in connection with certain transactions. One important situation is a transaction that would entail an obligation to make an open offer under the takeover regulations. But there is an important condition. The board of directors must be of the informed opinion that sharing the information is in the best interests of the company. So imagine ABC Limited is considering a major acquisition. The transaction requires sensitive information to be shared. Can the information be shared? Potentially, yes. But the board must properly consider the transaction and form the required informed opinion regarding the company's best interests. Second taxation exception. The source provision also deals with transactions that do not necessarily fall within the open offer situation. Again, the board must form the required informed opinion that the transaction is in the best interest of the company, and the information must be made generally available at least 2 trading days before the transaction is carried out. This is extremely important. The transaction may involve UPSI, but the regulatory framework requires the information to move into the public domain before the transaction proceeds in the manner specified. Practical example. Suppose ABC Limited wants to enter into a major corporate transaction. The board considers the transaction. The board forms a required opinion. The relevant information is then made generally available. The regulation requires the applicable waiting period before the transaction is carried out. So the compliance team must not simply ask, "Was the information or mission disclosed?" It must also ask, "When was it disclosed?" And how many trading days have passed? The 2 trading day rule. This is one number you should remember from today's lecture. 2 trading days, where the applicable provision requires the information to be made generally available before the transaction. The timing of that disclosure becomes critical. This is exactly the type of point that should appear in a Secretarial Audit checklist. Regulation 3, Sub-Regulation 4. Now suppose ABC Limited wants to enter into a contract with an external party. The contract involves UPSI. What should the company do? The board of directors must require the parties to the contract to keep the information confidential. They must not trade in the securities of the company while in possession of UPSI. This creates a contractual confidentiality layer around the information. Practical example. ABC Limited appoints a merchant banker for a fundraising transaction. The merchant banker receives UPSI. The engagement documentation should contain appropriate confidentiality obligations. The purpose is simple. The information should remain protected, and the person receiving the information should understand the restriction on trading while possessing UPSI. Regulation 3. Sub-Regulation 5. Structured Digital Database. Now we reach one of the most important practical compliance requirements. The board of directors or head of the organization must ensure that a structured digital database is maintained containing the nature of UPSI. It must also contain details of persons with whom such UPSI is shared, and the relevant identification details must be maintained. This creates an information trail. Who created the UPSI? Who shared it? Who received it? What information was shared? When was it shared? These questions become much easier to answer when the database is properly maintained. SEBI's FAQs also clarify that the structured digital database requirement applies to listed companies and relevant intermediaries and fiduciaries handling UPSI in the course of business. The big compliance lesson. The structured digital database is not just an Excel sheet that someone updates occasionally. It is part of the insider trading control system. The company should be able to identify the flow of UPSI. That is why the quality of the database matters. Internal maintenance. The regulation requires the structured digital database to be maintained internally. It should not simply be outsourced. SEBI's FAQs further explain that the board and compliance officer remain responsible for confidentiality, integrity, and security of the relevant data and logs. So imagine, the company secretary says, "Our vendor Mai maintains the database." That statement alone does not remove the company's responsibility. The compliance framework must remain under the company's control. Important practical point. Even when UPSI is shared only within the company, the required records still need to be maintained. SEBI's FAQ specifically confirms that the structured digital database requirement applies even where the information is shared internally. This is an excellent secretarial audit checkpoint. Regulation 3, Sub-Regulation 6, Preservation of Data. Now comes the record retention requirement. The structured digital database must be preserved for at least 8 years after completion of the relevant transactions. And if SEBI communicates information relating to an investigation or enforcement proceeding, the relevant information must be preserved until completion of that proceeding. So remember the number, 8 years. But if an investigation or enforcement proceeding is continuing, the relevant information must continue to be preserved. Practical secretarial audit question. Suppose the company secretary discovers that the company deleted its UPSI access records after 3 years. Would that be a compliance concern? Yes, because the required preservation period is much longer. The compliance team must have a proper record retention mechanism. Now the story changes. ABC Limited has controlled its information. The UPSI has been recorded. The relevant persons have been identified. Confidentiality requirements are in place. But now the CFO decides to trade. The CFO is still in possession of UPSI. What happens? Now we move to Regulation 4. Regulation 4. Trading when in possession of UPSI. The basic rule is extremely clear. An insider shall not trade in securities that are listed or proposed to be listed on a stock exchange when in possession of UPSI. This is one of the most important provisions in the entire insider trading framework. The central test. Imagine this situation. The CFO knows the financial results. The results are not yet public. The CFO buys shares. Now ask, did the CFO possess UPSI? Yes. Did the CFO trade? Yes. Then Regulation 4 becomes immediately relevant. Presumption. The regulation contains an explanation that when a person has traded while in possession of UPSI, the person's trades are presumed to have been motivated by the knowledge and awareness of that information. This is a very important legal principle. The insider may then seek to demonstrate circumstances supporting innocence as provided by the regulation. The big difference. Regulation 3 is about communication and procurement. Regulation 4 is about trading. So remember the distinction. Regulation 3 asks, was UPSI communicated or procured improperly? Regulation 4 asks, did an insider trade while in possession of UPSI? Practical example. ABC Limited is preparing quarterly results. Mr. X is an insider. Mr. X receives the draft results. The results are not public. Mr. X sells shares. Now the compliance team should immediately examine the UPSI. The date Mr. X received it, the date Mr. X traded, the date the information became generally available, the quantity and nature of the trade, and the circumstances surrounding the transaction. Off-market interstate transfer. The regulation provides circumstances in which an insider may demonstrate innocence. One situation involves an off-market interstate transfer between insiders who were in possession of the same unpublished price-sensitive information. The source provision requires that both parties have made a conscious and informed trade decision. This is an important exception framework. But remember, it is not a blanket permission to trade. The facts must satisfy the regulatory conditions. Practical example. Suppose two insiders already possess the same UPSI. They enter into an off-market interstate transfer. Both parties know the same information. Both make a conscious and informed decision. The transaction must still be examined against the precise conditions of the proviso. This is why you should never write in a compliance note, interstate transfer means automatically exempt. That would be too broad. Statutory or regulatory obligation. Another circumstance recognized by the regulation is where the transaction is carried out pursuant to a statutory or regulatory obligation. This is another example of why Regulation 4 cannot be read as a simple sentence. You must read the main prohibition together with its proviso and conditions. The big compliance lesson. When reviewing a trade by an insider, do not immediately conclude violation, but also do not immediately conclude exemption. First, identify the main prohibition. Then identify the facts. Then test the facts against the applicable proviso. That is the professional approach. Trading plan. The insider trading framework also recognizes trading plans as a mechanism through which an insider may demonstrate innocence in the circumstances specified by the regulations. SEBI's guidance confirms that Regulation 4 provides for circumstances in which an insider may demonstrate innocence and that a trading plan under Regulation 5 is one such mechanism. We will study trading plans separately in detail in a future lecture. Now bring everything together. ABC Limited has confidential financial results. The CFO receives the information. The CFO is an insider. The information is UPSI. The CFO sends the information to a consultant. Regulation 3 becomes relevant. The consultant receives the information. The company records the sharing in the structured digital database. The consultant later trades. Regulation 4 becomes relevant. Now imagine the CFO says, I never told the consultant to trade. That does not automatically solve the problem. The compliance team must examine the entire information and trading trail. The information trail. This is the real heart of today's lecture. UPSI is created. UPSI is identified. UPSI is shared. The sharing is recorded. The recipient is identified. The information remains confidential. The information becomes public. Trading occurs. The compliance team compares the dates. This is how insider trading compliance should work in practice. Your first question. Now let me test you. ABC Limited's CFO shares UPSI with its legal advisor because the legal advisor needs the information to perform professional duties. Is every such communication automatically prohibited? Comment yes or no. Think carefully. The correct answer is no. The regulation recognizes communication in furtherance of legitimate purposes, performance of duties, or discharge of legal obligations. But remember, legitimate purpose does not mean uncontrolled disclosure. The information must still be handled properly. Second question. Now suppose a person who is not an employee asks an insider for confidential financial results so that the person can trade before the announcement. Is that procurement of UPSI? Yes. And Regulation 3 Sub-Regulation 2 becomes relevant. Because the prohibition applies not only to the insider communicating the information, but also to a person procuring or causing its communication. Secretarial Audit Checklist. Now imagine you are preparing your Secretarial Audit working papers. For Regulation 3, check whether the company has controls over communication of UPSI. Check legitimate purpose. Check performance of duties. Check legal obligations. Check board consideration for applicable transactions. Check confidentiality agreements. Check non-disclosure obligations. Check the structured digital database. Check the nature of UPSI. Check names of persons with whom UPSI was shared. Check PAN or other permitted unique identifiers where applicable. Check dates and access trail. Check internal controls. Check preservation. And verify that the relevant records are retained for the prescribed period. For Regulation 4, check whether insiders traded while in possession of UPSI. Identify the UPSI. Identify when the person came into possession. Identify when the person traded. Identify when the information became generally available. Compare the timeline. Check whether any circumstance under the proviso is being relied upon. Check whether the transaction falls within the stated conditions. Document the conclusion. Final practical case. Now imagine this. ABC Limited's CFO receives UPSI on June 1st. On June 3rd, the CFO shares the information with a legal advisor for a legitimate corporate transaction. The company records the sharing in the structured digital database. On June 5th, the CFO buys shares. On June 8th, the company publicly announces the information. Now I have one question. What should the company secretary examine first? The purchase date. The date the CFO received UPSI. The date the information was shared. The date the information became public. And the applicable circumstances under Regulation 4. Why? Because insider trading analysis is a timeline exercise. Information, access, communication, trade, disclosure. Now suppose the CFO says, I bought the shares for a completely different reason. I had a personal financial requirement. Does that automatically prove innocence? No. The possession of UPSI and the timing of the trade must still be examined under Regulation 4. This is why documentation is so important. Let's close today's lecture. Regulation 3 controls communication and procurement of UPSI. An insider cannot freely communicate UPSI. A person cannot freely procure UPSI. Legitimate purposes, performance of duties, and legal obligations are recognized circumstances. Certain transactions can involve UPSI where the prescribed conditions are satisfied. Confidentiality and non-disclosure obligations are important. The structured digital database creates the information trail, and the database must be preserved for the prescribed period. Then, OMS Regulation 4. An insider cannot trade in listed or proposed to be listed securities while in possession of UPSI, subject to the regulatory framework and circumstances provided in the regulation. The big lesson. If Lecture 1 was about who is an insider, Lecture 2 is about what an insider must not do with UPSI. Do not misuse the information. Do not communicate it improperly. Do not procure it improperly. Do not trade while in possession of it. And maintain the evidence showing how the information moved. But there is still one major question. What if an insider genuinely needs to trade? What if the insider wants to sell shares for personal reasons? Can the insider trade after receiving UPSI? Is there a way to plan the trade in advance? What is a trading plan? Who can use it? What conditions apply? And can an approved trading plan protect an insider from the normal prohibition on trading while possessing UPSI? That is where our next lecture becomes extremely important. Because next, we move into the trading plan framework. And we will see how an insider can plan a trade without treating insider trading compliance is an afterthought. If you want to understand the SEBI insider trading regulations from the regulation itself to practical secretarial audit compliance, subscribe to Corporate and Securities Law Compass. Navigating the law with clarity. This is the SEBI Insider Masterclass series. Lecture 2. Remember, information creates responsibility. And in insider trading law, the question is not only what you knew, the question is what you did with what you knew. I will see you in Lecture 3.